Thank you for staying with us, and a warm welcome to those who've just joined us. The Constitutional Court has overturned a High Court ruling that declared Public Protector Busisiwe Mkhwebane's suspension invalid. The court found that President Cyril Ramaphosa had nothing to gain by suspending her. That was in relation to her office's investigation into the Phala farm matter. Handing down judgment earlier today, the court said there was no conflict of interest despite the fact that Ramaphosa was being investigated. It also found that he had no power to influence who would stand in for Mkhwebane or sway the Phala investigation.
On the suspension of Advocate Busisiwe Mkhwebane, the Constitutional Court judgment affirms the fact that the President acted within the rule of law, and it also affirms the President's adherence to due process and fairness. As you all know, the suspension followed the decision by the National Assembly to institute a Section 194 process against Advocate Mkhwebane. So in short, we welcome the decision, and this decision confirms that at all times the President endeavors to act within the prescripts of the law.
All right, let's get some legal reaction now and analysis on that story. We're joined by constitutional law expert, Professor Pierre de Vos. Prof, thank you very much for your time here on ENCA. Did you expect the ruling to go in this direction?
Yes, it would have been surprising if it had gone in a different direction. As the court points out, in a case like this with an independent body like the Public Protector, the same would apply, I think, to judges in courts. If there are credible allegations made and an independent fact-finding body, the experts in terms of the Public Protector or in judges, the Conduct Tribunal, they found that there is a case to answer, then to protect the body, the status of the body, it's almost always going to be irrational not to then suspend that person until the process and the inquiry has been completed.
And I mean, obviously, Prof, it was also the fact that then when the President did suspend the Public Protector in June, he said that it was because of the findings of an investigation that was done by the former judge of the Constitutional Court, Blessing Kabinde, when it comes to some of her conduct, how many times she's been found to have not properly read the law, etc. But of course, her argument in the High Court was that it was just surprising the timing of the President, as she said, the Phala, or rather her office would investigate Phala, then he suspends her. So do you think the High Court maybe got too involved in the politics of this particular case?
No, I can't answer that question, but I would say what the High Court did is that it focused very narrowly on those 3 days when the Public Protector sent the President the questions about Phala, and then he suspended her after that. But of course, the process to suspend that started 6 months later. And for me, what is interesting about the Constitutional Court judgment, it said if the President can be faulted is that it took so long to suspend her. It should not have taken until the time that he did that he suspended her. He should have suspended her long before that, exactly to protect the integrity of the institution. So it was obviously dumb of him to do it 2 days after he got sent the letters because it looks suspicious. But if you take all the facts, it's very difficult, given the fact that there are such overwhelming reasons to suspend, that alone could have made the finding that the High Court did.
I was also interested, of course, she has every right to, go to any legal avenue in terms of judgments. But of course, the High Court judgment was actually for her. And I was interested in what the Deputy Chief Justice said in her judgment today. She said, we also, as the Constitutional Court, have found her wanting in many of her reports and, recommendations before.
Yes, so that, for me, that is, in a way, it's at the heart of the Constitutional Court judgment, saying that if you have somebody that heads an independent body, if the court makes all these findings and then an independent panel headed by a retired judge find that there is a case to answer, and then the process goes forward, then it's inevitable that the person needs to be suspended, whether it's the public protector, whether I think the court didn't say that, whether it's a judge of the High Court, whether it is a commissioner of the Human Rights Commission or whatever. I think that is an important principle. I hope that the president in the future will take heed of this and take seriously his duty to suspend people, not to punish them. It's not a punishment, it's a precautionary suspension, regardless of who they are, regardless of what the perceptions about their politics might be or whatever the case may be.
And of course, I mean, it was former Justice Mkhwebane who said that she found that there was prima facie evidence that pointed to the public protector or the now suspended public protector's incompetence. So by taking, her suspension to court and forgetting that particular report, do you think it also questioned Justice Mkhwebane's independence?
No, because although as the Constitutional Court points out, although the public protector suggests that she did engage with the merits of the matter of the case against her for impeachment, she didn't really take that up. She made technical arguments, so she didn't full-on challenge that. Of course, the committee, the ad hoc committee before the National Assembly, is now busy with the task of seeing whether that report should be confirmed or whether the case is one that warrants impeachment. But normally in a case like that, the person then will be suspended precautionary until the inquiry is fully completed.
Last question, Prof. I wonder if you can give me an answer, because maybe I'm putting you in a corner. Do you think she made a mistake, she and her legal team made a mistake in that, as you said, in terms of Justice Mkhwebane's report, telling the court that, yeah, she did consider those recommendations, but, she didn't, she argued more on, the technical issues that had to do with the timing of her suspension and what she was investigating then, and the president having, or having influence on who would, stand in while she's suspended as public protector, etc. Do you think she made a mistake with her legal team to concentrate her argument in the High Court on that?
No, I actually think because these kind of issues, and in this particular case, is both a legal. There's a legal aspect. There's a political aspect. I think that there was no case that the suspension was irrational, but the best possible argument was to say that the president is conflicted, biased, because she was going to investigate him. And that's also politically the most helpful, because that if you are critical of President Ramaphosa, as she is perceived to be, because that creates then further questions about the integrity of the president. So it was a losing strategy, but it was probably the best one available there.
All right. Well, thank you so much for speaking to us and giving us your expertise. That is Professor Pierre de Vos. He is a constitutional law expert.